Now, the assigner also retains the right to decide at the time of retirement or receipt of a worker's compensation to maintain more than the minimum of his or her basic life package. The assigner also continues to be responsible for the premiums, and the premiums will be withheld from the assigner's pay, their annuity, or any type of compensation. So OPM does enforce the payment of it so that the individual who had made the assignment, the assigner, cannot just simply go in and cancel the coverage that once it's been assigned. So the final section that we're going to cover, and then we'll open it up, I'll go through a brief conversation about the high 3 average, are the roles and responsibilities of each group. Now, the employing agency is the proper source for the employee to get information from, because the agency retains the electronic official personnel file. OPM does not receive those records until the employee separates from employment. So the employing agency would be the ones responsible for the enrollments for the former spouses and receives premiums, as well as makes any assignment of the life insurance of the employee that they may make. Now remember, for the health insurance, the former spouse pays the full cost plus the government rate. Now, the agency may provide in response to a subpoena signed by a judge or release a signed statement from the employee for the retirement system coverage to talk about the amount of money that's withheld by the agency to the employee's credit in the retirement fund and an annuity estimated using the date to service. Now, agencies can only prepare estimates on what the employee has already earned. The agency cannot provide estimates that involve speculation or in any way attempt to advise an employee, spouse, or attorney about how to draft the court order. Now, as far as OPM's roles, their role is strictly ministerial. So OPM makes a determination regarding the acceptability of the court order and the rights and the benefits. Now, this is an important part that's often not taken into effect by the former spouse or by the employee. That COAP must be submitted and approved by OPM prior to the divorce. If an employee waits until the time of retirement and attempts to submit the information, it will cause a delay. And as most of you on this call know, that is already an elongated process, so it's just going to further exacerbate it. Now, OPM informs the former spouse that the court order is acceptable, the date of the spousal benefit to begin to accrue, if known, and the monthly benefit and formula used to compute it. If the individual, he or she, disagrees with OPM's assessment, then they must also get an additional clarifying court order, must be, again, submitted to OPM and reviewed and approved by OPM. Now, as far as the effective parties, they must apply for the benefits along with a certified copy of the divorce decree, legal separation, or other court and other supporting documents to OPM. And as an example, property settlements, marital separation agreements, referenced and incorporated into final decrees. They also must keep OPM advised of current mailing addresses and living statuses of both the former spouse who is claiming the benefit and the federal employee whose benefits are being affected. So also, if there's any changes to circumstances that could affect benefits, submit all disputes with the employee and retiree to the appropriate state court for resolution. The former spouse should file the information as soon as possible. A former spouse must apply in writing to be eligible for a court-ordered apportionment of the employee's annuity. There is no special forms that are required. If the former spouse is incompetent, a representative may apply on their behalf. So for information about court order benefits, this is how you would contact OPM. There's a phone number, 888-767-6738, or by email, or there's the Office of Personnel Management in Washington, D.C. So what I'm going to do now is I'm just going to take just a few moments to talk about how the high 3 is determined. Now, the high 3 average consists of the highest 36 consecutive months, no matter when it occurs in an employee's career. So it includes base and locality. Now, there's some exceptions that are not included. Those would be things such as overtime pay, holiday pay, travel pay outside the regular tour of duty, Now, if an individual gets a specialty pay, that will count. But the exception to this would be individuals who would be classified under law enforcement, air traffic controller, those and firefighters. Those special provisions, overtime does count, or unavailable, or LEAP, which is law enforcement availability pay, or uncontrolled overtime pay. So those would be the exceptions to the high 3 average. And again, they look at the highest 36 consecutive months, no matter when it occurs during the career of the employee. So what I think we'll do now, Nick, is we'll go ahead and open it up for questions and to see if there's any additional information that people may have about the program before we close out.
All right, sounds good. Seems like unmuting, if folks want to type in the questions, that's great. I will try to unmute everybody, but we do get some noise. I'm doing it individually. Sean, we have about 2/3 of the people unmuted.
Okay. All right. Well, it sounds like we don't have any questions, Nick, so let's go ahead and mute them. The final thing is a little bit about my company, Federal Employee Benefits Advocates. We do federal employee briefings for federal agencies all over the country. We've been doing it now. I've been working with federal employees now for about 10 years. And during that period of time, I've probably spoken to somewhere in the neighborhood of about 17,000 federal employees. We are considered a government contractor. We do have the CAGE code, and we do have information available about the services that we provide. So we do provide information on full day, half day briefings for both CSRS and as well as the FERS. We also have a financial literacy program that we can provide. Now, these programs do comply with the requirement that OPM says that the agencies are required for coming up with providing financial literacy at the early, mid, and late career. So these programs are in compliance with that program. So again, I'd like to thank each and every one of you for participating today. I'd also like to thank Linda Duncan for taking the time and the effort to put this together for the organization. If you do have additional questions after the conclusion of this, you can certainly contact us at info@febadvocates.com, or you can visit our website at www.febadvocates.com. So with that, we'll conclude today's session. Thank you very much for participating. And again, have a good rest of the week and a great Labor Day weekend. Thanks, everyone.
Thanks, Sean. Have a good day.